Hi, this week we're going to be talking about Chapter 21 and 22 in our business law book. Chapter 21 is about the employment discrimination. Employment at will doctrine is a contract of employment for an indeterminate term and is terminable at will by either the employer or the employee. The public policy exception is an exception to the employment at will doctrine that makes it unlawful to dismiss an employee for taking certain actions in the public interest. Examples of this would be whistleblowing, or someone may be filing for workmen's compensation claims. 11 states have recognized the implied covenant of good faith and fair dealing exception. This theory holds that every employment contract, even an unwritten one, contains an implicit understanding that the parties will deal fairly with one another. The first major Civil Rights Act was passed immediately after the Civil War, the Civil Rights Act of 1866. And this was to guarantee that all persons in the United States have the same right to make and enforce contracts and have the full and equal benefit of the law. The Civil Rights Act of 1871 prohibits discrimination by state and local governments. The next major piece of federal legislation to address the problem of discrimination was the Equal Pay Act of 1963, an amendment to the Fair Labor Standards Act. This came into play when women joined the workforce and was making 60% less than men in the same job. Title VII is a statute that prohibits discrimination in firing, hiring, or other terms and conditions of employment on the basis of race, color, religion, sex, or national origin. Disparate treatment occurs when the employer treats one employee less favorably than another because of the employee's color, race, religion, sex, or national origin. Disparate impact occurs when the employer's facially neutral policy or practice has a discriminatory effect on employees who belong to a protected class. The third way to prove discrimination is to demonstrate harassment. Sexual harassment is unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct or sexual nature that explicitly makes submission a term or condition of employment or creates an intimidating, hostile, or an offensive work environment. The Age Discrimination Employment Act of 1967 was enacted to prohibit employers from refusing to hire, discharge, or discriminate in terms and conditions of employment on the basis of age. An exception to this rule is the executive exemption, which is if an employee has been employed as a bona fide executive for at least 2 years immediately before retirement, and upon retirement, he or she is entitled to non-forfeitable annual retirement benefits of at least $44,000. The company can terminate an older employee as long as those two things apply to the employee. In 1973, Congress broadened the class of individuals protected against discrimination to include the handicapped by passing the Rehabilitation Act of 1973. Excuse me. The Rehabilitation Act of 1973 prohibits discrimination in employment against otherwise qualified persons who have a handicap. This applies only to the federal government. Employers that have contracts with the federal government and parties who administer programs that receive federal financial assistance. Americans with Disabilities Act of 1991 is intended to prevent employers from discriminating against employees and applicants that have disabilities by requiring employers to make reasonable accommodations to the known physical or mental disabilities of an otherwise qualified person with a disability, unless the necessary accommodation would impose an undue burden on the employer's business. One of the most controversial workplace issues of the past 2 decades has been the legitimacy of the affirmative action plans. That was the summary of Chapter 21. Chapter 22 deals with the environmental law. The first attempts to regulate pollution were through the use of the tort law, in particular through the use of tort of nuisance. A nuisance is an unreasonable interference with someone else's use and enjoyment of his or her land. Technology enforcing standards are set primarily on the basis of health considerations, with the assumption that once standards have been established, the industries will be forced to develop the technology needed to meet the standards. The technology-driven standards, in contrast, try to achieve the greatest improvements possible with existing levels of technology. It requires the best control system possible, given the limits of that technology. The Environmental Protection Agency, the EPA, is the federal agency charged with the responsibility of conducting an integrated, coordinated attack on all forms of pollution of the environment. The EPA is one of the largest federal agencies, having approximately 17,384 employees as of the year 2011. The Environmental Impact Statement, the EIS, is a statement that must be prepared for every major federal activity that would significantly affect the quality of the human environment. In 1972, Congress passed amendments to the Federal Water Pollution Control Act to establish two goals. One, fishable and swimmable waters by 1983, and two, the total elimination of pollutant discharges into navigable waters by 1985. The Federal Water Pollution Control Act amendments was established and enforced an enforcement point source effluent limitations. Point sources are distinct places from which pollutants can be discharged into water, such as paper mills, electric utility plants, sewage treatment facilities, and factories. Effluent limitations, maximum allowable amounts of pollutants that can be discharged from a point source within a given period of time. A second major concern, is protecting the quality of the air. The National Ambient Air Quality Standards, which is the NAAQS, is a two-tiered set of standards that's developed for the chief conventional air pollutants. Primary standards designed to protect public health, and secondary standards are designed to protect public welfare. State implementation plan is a plan required of every state that explains how the state will meet federal air pollution standards. One of the main air quality problems facing the United States as well as other countries is acid rain. Roughly 75% of acid rain is caused by emissions of sulfur dioxide and nitrogen oxides from burning fossil fuels by electric utilities. The Clean Air Act amendments included an innovative approach to controlling sulfur dioxide emissions. A manifest program. This is a program that attempts to see the hazardous wastes that are properly transported to disposal facilities licensed by the EPA, so that the agency will have an accurate record or a manifest of the location and amount of all hazardous waste. Hazardous waste is any waste material that is ignitable, corrosive, reactive, or toxic when it's ingested or absorbed. The Resource Conservation and Recovery Act of 1976, which is the RCRA, regulates both hazardous and non-hazardous waste with the primary emphasis on control of hazardous waste. The Comprehensive Environmental Response, Compensation, and Liability Act, as amended by the Superfund Amendment and Reauthorization Act of 1986. Superfund is a fund that's authorized by CERCLA to cover the cost of cleaning up hazardous waste disposal sites which owners cannot be found or are unwilling or unable to pay for the cleanup. The Toxic Substances Control Act of 1979 reviews the type of substances that's regulated. A toxic substance is any chemical or mixture whose manufacture, processing, distribution, use, or disposal presents an unreasonable risk of harm to human health or the environment. One category of toxic substances that has been singled out for special regulatory treatment is pesticides, which are defined as substances designed to prevent, destroy, repel, or mitigate any pest, or to be used as a plant regulator or a defoliant. Insecticides, fungicides, and rodenticides are all examples of pesticides. In 1972, the Federal Insecticide, Fungicide, and Rodenticide Act created the registration system that is used to control pesticide use. A pesticide will be registered when it, number one, its competition warrants the claims made for it. And number 2, its label complies with the Act. And number 3, the manufacturer provides data to demonstrate that the pesticide can perform its intended function when used in accordance with commonly accepted practice without presenting unreasonable risks to human health or the environment. That is our summary of Chapter 22. I will see you next week. Thank you.